Thank you for being with us here on the Joy News channel. This is The Pulse, but we're starting off with a breaking story for you this afternoon here on the Joy News channel, where an Accra High Court has just sentenced the founder of defunct Capital Bank, William Essien, to 15 years in prison with hard labor. We're getting more details on this and crossing you over now to the court premises where all of the action is happening. My colleague Richard Kujinyako and Kweku Asante are live on the grounds for us as this story unfolds. Kweku, let's start off with the shocking judgment coming through, because there was a lifeline handed over to William Essien. How come the court is changing its mind now? Well, Asante, if you can hear me, I was just asking about the latest. What's the reasoning of the court and why is this decision being taken?
And for Mr. Essien, but he had failed to pick up that deadline on 2 occasions because he had not paid the requisite amount. But our colleague Richard Kujinyako sat through court proceedings through Yes, I'm blessed. Like I'm telling you, the founder of the defunct bank had 2 lifelines, like you mentioned, to actually pay up those amounts or go to jail. He had not paid that amount. Richard Kujinyako sat through proceedings for us. So, Richard, what was the reasoning of the court in handing out this judgment?
Well, so the court took notice of the fact that on the 27th of July 2023, Mr. Essien was given a lifeline to pay the remaining amount. So that was 55 million Ghana cedis. So the judge indicated that he expected Mr. Essien to redeem himself, having that long stretch of time from the vacation period up to 2 months. So today when they came to court, he was expecting the news from Mr. Essien that I have the money, I am coming to pay. So he defaulted in the April deadline and then defaulted in the August 31st deadline, and which gave the court no other option than to pass a sentence on him. You know that the court held the sentence in abeyance because they reached an agreement, and the agreement was that he was supposed to pay them in tranches. And so the first tranche elapsed, he couldn't pay, and then the second tranche, and so the last tranche was going to be in December. And so today, Mr. Essien held before Thaddeus Sorry and indicated or pleaded with the courts that, well, they have done a lot, and then they have put in place mechanisms to ensure that they get the money to pay. And so the court should temper justice with mercy and give them some more time in order to pay. But the court said they have granted them enough time, and if they continue to give them time, they do not know to which end they are going to give that kind of time. And so a motion was filed by the state, by the Republic, passing or urging the court to pass a custodial sentence on Mr. Essien, and the court obliged.
So you are telling us that all these pleas by lawyers for Mr. Essien were simply not listened to by the court. Tell us also about the counts. There were several counts. In fact, if you look at all the counts and the sentencing, it could pass off around 90 years plus. But that is not actually how long Mr. Essien is going to spend in court. He's going to spend 15 years in hard labor. Tell us about those details and how you are computing this term of jail.
So his charges related to stealing, conspiracy to steal, money laundering, and all of that. So when the judge put all of them together, about 16 of the counts, and so he counted. With each count, he passed a sentence. Some of the sentence range from 1 year, 2 years, some 10 years, some 7 years, some 11 years, and all of that. But the highest sentence related to stealing, and which he had 15 years, considering the fact that he is a first offender. And the court also took notice of the fact that his actions caused incalculable losses of jobs to innocent citizens, considering the fact that he actually took money and decided to open his own bank as well. And so he, by so doing, other people were deprived of jobs and the others. So when you put all the count together and the sentences together, it went up to 95 years. So he was supposed to serve 95 years, but because he's serving them concurrently, we take the highest form of sentence, which is 15. And so that is why Mr. Essien is going in for 15 years.
There were plea for mitigation. In fact, NDC's Director of Legal Affairs, Eduji Kujutamaklo, who had handled an earlier case, hanged around, and they were all pleas for mitigation. Tell us about the plea of mitigation first, and whether or not that played any role in the judge's handling down of this judgment.
Well, so two were raised. I mean, so when the motion was filed, they opposed the motion based on two grounds. The first is that the convict respondent had exhibited utmost good faith. He did not go to sleep. In fact, he did all he could to raise 37 million Ghana cedis out of the 90 million Ghana cedis he was supposed to pay. And there are other things that were also set in motion to enable him pay. And so that is the first one. And then the second one, he's a married man, he has children, he's a breadwinner of the family and all of that. And should the state go ahead to pass that sentence on him, the state's ability to retrieve the monies that are left, the 53 million that is left for him to pay, will be very difficult, because now when the sentence was passed on him and the license was revoked, he was not working, he couldn't travel, and he has some works and businesses overseas, and so he couldn't do anything. So the court should take into consideration these facts that they have put before him, and then grant them 6 more months to enable them pay. So that was the last thing that Mr. Bonsuishia indicated, that the court should, for the final time and the last time, grant Mr. Essien 6 more months to enable them pay. In fact, there was this project at Pram Pram that was valued at $10 million, and he said that they are in the process of doing that, and so should they even get that amount, it will be able to offset the remaining amount that they have. And so these were the plea of Mr. Essien's lawyers.
Right. So, like you heard there, the breaking news story we are covering for you right here at the High Court complex is that the founder of the now defunct Capital Bank, Mr. Essien, has been jailed 15 years, and he's going to jail 15 years in hard labor. And if you look at the totality of the sentence, it runs up to 95 years. But because they are all running concurrently, the court has handed down a sentence with Mr. Essien expected to spend 15 years in jail. William Essien was personally in court wearing a mask, his demeanor and other things. We'll just get into that very shortly. But the plea for mitigation, we are expecting the High Court's full ruling at a later date. We'll know whether or not this plea of mitigation played any role in Justice Eric Chebafor's judgment. Of course, if it did not, then it will mean that if the plea was taken, the sentence could have come down a little bit. But if it was not taken, it means that it could have gone a little bit higher. So it appears all that will come into some...
So the judge took into consideration all of this, because he stated that for one of the sentences, Mr. Essien could have gone in for 25 years. There was one that he could have gone in for more than 20 years. But because he acceded to the plea that they put before him, and that is why they were all reduced, considering the fact that he was a first-time offender, and then he took steps to pay. But the judge also indicated something, that when Mr. Essien continued to plead not guilty and allowed the state to call witnesses, about 17 of the witnesses, and then wasted everybody's time until the final day when he saw that judgment was going to be passed, and then pleaded guilty. All of these things, he also took them into consideration. Otherwise, maybe the sentence could have come down if he had pleaded guilty from the outset.
So if Mr. Essien pleaded guilty from the start, he could have gotten a much lesser sentencing. But as it is now, he's going to spend 15 years in jail in hard labor. What was the demeanor of Mr. Essien in court whilst all this was happening? I entered the court at some point, I saw him, lawyers around him trying to calm him down. What was his demeanor throughout the proceedings today?
Well, so I saw him in the company of a very beautiful woman, a fair-colored woman. I don't know whether that woman is the wife. That woman kept on bowing the head and then listening to the proceedings. Mr. Essien himself was in mask, and at the time the sentence was passed, I saw him, the eyes were teary. I don't know, he was very sad. So a lot of the people, the lawyers, you saw Eduji Tamaklo and then his lawyer Bonsuishia also go there to console him. I don't know, I mean, the words they exchanged with him, maybe they were trying to say that, well, it will be well. For 15 years, you may come back and all of that. We can also even go back, plead with the state, make the payment, sell the asset and all of that. So calm down. This is not the end of the world. Other people have gone. So someone used to say something that it is for these comparisons. That is why people that are in prison, they don't really bother, because you'll be there, you serve, you are in jail for 10 years. Someone, you cry, someone comes and then he's been convicted and sentenced to 35 years. You say, oh, okay, mine is 10 years. And so I presume that these were some of the conversations they had with Mr. Essien.
Yes. Eduji Tamaklo just walking around here, and that was the plea of mitigation that they put in, and it appeared to have convinced the judge a little to sentence Mr. Essien to 15 years in jail. Mr. Essien is the founder. He was the leader of the now defunct the defunct bank, Capital Bank, and that bank went under. Was part of the cleanup exercise, and we will try and see if we can get Eduji Tamaklo briefly to see if we can speak to him. He's just starting his car. He had some plea of mitigation, and he has just started his car trying to leave. But the breaking news: Mr. Essien is going to jail for 15 years, and for his role in the collapse of that bank. The bank lost a lot of money, and they could not handle all of that. But that is not the only case we'll be handling in court today. It's been a really packed day in court, and as the day goes by, I'm sure we're going to get a lot of reaction from the Attorney General's department on this particular case where Mr. Essien has been jailed for 15 years. There was also the case of the special prosecutor. He was expected to be in court today to hear the application, to actually make the application for the confirmation of the seizure order of Madam Cecilia Dapaah's property. But at the last minute, Richard, we get to know that has not been dealt with. And so, Richard, I'll come to you back shortly, but let me hand you over back to Blessed for some more conversation on this. But when we come back, you will hear about the Cecilia Dapaah case, the special prosecutor now filing a petition to the Chief Justice of the Republic, asking that the judge hearing the matter be recused from hearing any of the OSP-related matters currently before him. There was the Aisha 1 case, and there was also Dr. Stephen Opuni trying to stop his case from proceeding so that some proceeding and some matters will be corrected. He also did not find favor in the eyes of the law today. So, Blessed, this is the Essien case, the breaking news we've been covering for you live here at the High Court Complex. The CEO of the now defunct Capital Bank jailed 15 years in hard labor.
My colleague Kweku Asante there with the very latest that we're learning of the case relating to the founder of the defunct Capital Bank, William Essien, who's now being confirmed to be sentenced 15 years in prison by an Accra High Court. A packed day it has been. In fact, there's more unfolding even on the OSP case that we'll be getting back to Kweku and Richard back in court. But Raymond Akwa is joining us here in studio to break it all down for you, so you're able to, get a better perspective on this matter. Raymond, grateful that you're spending some time with us here to explain where it all started from, because for many of us, we recall that lifeline given by the court to Essien to pay up some amount of money, and then he would be walking free. That did not happen. But let's go back. Where did this all start?
Of course, he paid a certain amount of it, but could not pay all. That's where the other difficulties came in. But let's go back to 2018. And even if you want to go before that time, there was in 2014 and 2015 a certain asset quality review that was done for the Bank of Ghana to determine the asset quality review of various banks. They needed help. So the then government got them some help. Some got bailouts, as we used to call it. And that Capital Bank was up to 620 million. That is the beginning of the conversation here. Let's not forget that Mr. Essien is actually the largest shareholder of the bank. There are other people who, together with him, were hauled before the courts on that. Some were dropped along the line. Then proceeding beyond that, the government took the view that Mr. Essien and co misappropriated the amount of money that was given, the 620 million, in different formats that they didn't like. They mentioned the setting up of certain other institutions and also monies that they couldn't account for. In fact, that's what brought in the charge of stealing along the line, because they could not. This was monies meant to bail out the bank, but were deemed to have been misappropriated or stolen in this particular case. The case moved on, and somewhere in 2021, we're supposed to get judgment from the court. Remember, that's when along the line, we had introduced the new law that allowed people to return cash to the state when we found that they admitted to the wrongdoing here. So he then pleaded, and after calling 17 different witnesses, the state closed his case. Then Mr. Essien was supposed to reopen his case. First, there were some hiccups with that. Then subsequently, he was given the opportunity to open up or his defense in this case. He proceeded with that particular defense. Then after they went through that process too, came back, agreed with the states, with the Attorney General's office. So remember, it was a very contentious issue as to whether or not we should allow people to pay when they had actually been found or were going to be found guilty of some of these offenses. But the state had an agreement with him to pay back some of the money. You recall that confusion around Justice Cheba for saying or alluding to the fact that this was not supposed to be a proper process. Initially, we were told that if he failed to pay, we could reactivate the process of jailing him.
And that was a clear warning.
Yes, we were told right from the beginning that if he failed to pay, Mr. Essien on 2 different occasions had gone back to the court to ask for some other lenient terms. He was given one in the first instance. In fact, there was even an extension in the second deadline that was supposed to be given. It is the failure to go by that second deadline and seeking a further engagement on this, which became problematic, which then led to the state insisting that Mr. Essien should be committed to jail.
In fact, there's a bigger question now as to what the legal options are. If Mr. Essien, together with the legal team, are able to confirm that, well, we have the funding now, will the court reverse its decision or perhaps revise the case?
It's one of the issues that came up in the earlier engagement. That at what point can we say that you have raised the money, even if you have changed? Because it were 2 routes that were suggested.
Settle and you walk free.
Yes, and you walk free. If you are unable to pay, you go to jail and serve the sentence. The argument at the time was that it was of no use to everybody in the Republic of Ghana to incarcerate Mr. Essien when the alternative could be he will pay and get back the money from him.
I see.
It had always been difficult, and the people who defended this law had been clear in their minds that it had always been difficult to incarcerate and recoup the money. So that was where the difficulty was going to be like. Will he be able to raise the money now? Is he also required within the period to raise the money? We need to see how and when they will have to file before the same judge for some understanding of this. So it's almost like we truncated your judgment or your sentencing because you've been found guilty. That was settled. We truncated your sentencing to give you a leeway out. And this leeway was that if you get us an amount of money, and it was not even an amount that was being discussed out there in the first place. It was a lower amount that was being given in the first place. So if you're able to pay according to the terms that we give you,
then you are free.
So if you follow the terms properly, and people were even adduced to the fact that he had paid some amount of the money. I mean, he had actually indicated to the court that he was interested in paying the rest of the money within a period that he was not able to raise the money. That is what brought the confusion here. So as to whether or not getting the money later on can now go back to renegotiate this, it will be what he will put before that same court. And basically ask for some understanding on this one. But will the court listen to him, mindful of how he had dealt with this matter? Mindful of his conduct in this particular case.
And what's also instructive, that this is not just a 15-year jail term, there's also hard labor. Implications?
No, I mean, it's a term that we give.
We shouldn't be laughing about this. But
no, it's a very serious matter. You can be in prison. But this one, you have to work very, very hard alongside that. And that's how difficult that's supposed to be. I mean, for a man of his age, for a man of his comfort and living and luxury, would he be able to live under those circumstances? But of course, we cannot discriminate merely because you used to live a very luxurious lifestyle or you were a man of comfort previously. The argument generally has been that how we treat some of these crimes do not only serve as a reminder to people that it's not only the punitive nature of it that matters, that it's also deterrent to a certain population, that this is something we generally do not want people to be doing. Let's not forget, the collapse of the banks led to a massive debt on our hands. Government still quotes something around 22 billion. Let's not forget that. We used 22 billion to resolve these banks. Beyond that, people lost their jobs. People struggled to retrieve the amount of money they're supposed to be having with some of these institutions. Let's also not forget that we had absorbed some of these banks under a new engagement of CBG and carried on its operations beyond that. Those who are of the opinion we need to send a signal, and that's the difficulty with banking resolutions. If you do not do it properly, it leaves a very lasting image on the entire financial system because they are interconnected at various levels.
And in fact, the argument is already starting as to whether or not government should feel vindicated for its banking sector cleanup, a reason for which, Essien is being jailed now. The questions about this giving morale to the Attorney General to go after more and more persons who are cited in various reforms.
Initially, and that was in the civil case, there were 15 or 17 people that were held before court, including the board chairman of the Capital Bank. Those were related to what we call the civil case.
Right.
Now, we also had a criminal case ongoing. Let's not forget that initially it was not only Mr. Essien that was in this particular end. There were other people who were later on let go. So the prosecution took it from a certain level. Many people were still very dissatisfied with the pace at which this prosecution was going because they needed a signal to be sent to people. Let's not forget that what happened in the US after the financial crisis, there were still calls that people who were at the heart of it should be dealt with properly. Why are financial crimes of this nature important? It's because people think that ownership of bank is as if it's only your money that's in the bank. It's not true. It's because you take depositors' money and somebody had to jump in to come and guarantee that the depositors will get their money, even if you mess up with the money. I hope you get the point. And the arguments that were being made at the time, about which options to choose in resolving financial crisis is after a bailout. If you go through administration, could we have, for example, decided that we are replacing the leadership of the bank without dissolving the banks, the ones that were dissolved? Or as we chose to now spend this amount of money, could we have spent a far lesser amount of money in that case?
I see.
But that is separate from we believing that you have committed a crime and that you should be dealt with separately on this one.
Raymond, it's going to be a long day because so many activities in court as we speak, but grateful for giving us all of the updates. We'll definitely be breaking down this further and getting Raymond to explain a bit more to us. But we cross over again to the courts because even as we speak, the Office of the Special Prosecutor is requesting the Chief Justice to remove His Lordship Edward Choom from the case or all cases involving the OSP pending before him. Now, according to the Special Prosecutor, the request is grounded on the OSP's well-founded belief that Justice Edward Choom appears to be highly prejudiced against the OSP and person of the Special Prosecutor. My colleague Richard Kochunyako and, of course, Kweku Asante are still in court for us. So, Kweku, let's get back to the second case, which is also of interest to Ghanaians as we speak, the issue about the OSP raising concerns with the manner in which the Cecilia Abena-Dapaah case is being dealt with. What's been happening in court?
To this. In fact, they brutally responded to this petition. They felt that the Office of the Special Prosecutor has not really dealt well with them. In fact, first of all, he should have been in court personally because, the cases were two, one a criminal case and then the civil case. So the first one is for the confirmation of seizure of the cash sums that were seized from the matrimonial home of Madam Cecilia Abena-Dapaah. The second one was confirmation for the freezing order of the bank account of Madam Cecilia Dapaah. But the Office of the Special Prosecutor wrote to the Chief Justice petitioning him to let the judge recuse or remove the judge from anything related, any trial or any sitting related to Justice Edward Choom, because according to him, it is not only his attitude and conduct is not only towards the Office of the Special Prosecutor, but to the Special Prosecutor himself. So there are two, the office in general and the Special Prosecutor himself. And so that was what the petition was about. They feel that the judge will be biased. Remember that it was the same judge who refused the confirmation of application, the earlier one that was filed, and so it was the same judge that also granted the abridgment of time yesterday. And so taking all of these things in totality and then the conduct according to the Office of the Special Prosecutor, if the judge is allowed to sit on the case to to look at the confirmation of the thing, maybe it will not augur well for them. And so that's why he is asking the Chief Justice to enable the judge to recuse. But the lawyers for the former sanitation minister, they feel that the Office of the Special Prosecutor has not really dealt well with them. And so that is really their comment.
Right. So we've heard from the lawyer, from Madam Cecilia Dapa, who was really fierce on the feet, in fact punching holes to some of the applications that the Special Prosecutor had filed. The criminal matter having to do with Cecilia Dapa and the failure to disclose properties is also before Justice Chum.
Yes, exactly. So the Office of the Special Prosecutor served some forms on Madam Cecilia Dapa for her to fill in relation to her property, the property that she has. But according to the Office of the Special Prosecutor, within a period of 30 days, the former minister failed to respond to the service on her, and that is why they have initiated the criminal proceedings against her. And so that is what is related to that. But the lawyers of Madam Cecilia Dapa indicate that the service was not even properly done. They also even say that the Office of the Special Prosecutor is just buying time, and such conduct is having an adverse effect on Madam Cecilia Dapa, because here is a woman whose cash has been seized, whose bank account has been frozen, and she has no money. And so why continue to buy time when they even filed for the abridgment of time? They opposed to that application, and they wanted to maintain the 18th of October, the original date when they were supposed to come. And so in totality, he feels that the Attorney General has been unethical, because he should have been present. And there is no law, no procedure within our jurisprudence that when someone files or a petition to the chief before the Chief Justice, that particular person cannot appear in court or even serve notice to the other party, so that they will be well versed with whatever decision they are taking. And secondly, he feels that there was no complaint made about the conduct of the judge, so they have all been taken by surprise that they come to court and then a service has been given to them that the OSP has filed a petition. And so that is by way of response that the lawyers from Madam Cecilia Dapa gave.
Yes, so Madam Cecilia Dapa's lawyers making a strong case in court why they believe that that is not an important petition to file against the hearing. But Richard, we're in court for other matters.
Exactly.
Aisha 1 and the likes.
Exactly. So what happened in the case of Aisha 1?
So today we expected that Aisha 1's case, the judgment will be delivered today. But as it were, what was expected to happen was the filing of the written addresses. And so the written addresses, as we know now, have been filed by both the prosecution led by the Attorney General himself and also the defense lawyers. We know that all throughout, Madam Aisha 1, and 1, popularly known as Aisha 1, has denied any involvement with galamsey in the country. In fact, she goes as far as to say that she has not even visited any of the illegal mining sites that government says that she has been going onto. So the judgment is now expected on the 4th of December. 4th of December, Madam Aisha 1 will decide, her fate will be decided by the criminal court here in Accra as to whether or not she gets to go to jail or she will be freed based on the evidence that have been taken by both the prosecution in terms of the delivery of that and the defense that have been put out by the lawyers for Madam Aisha 1.
Was N1 herself in court today?
So she was not. This was simply the lawyers filing their, while in the US and other places we call the closing addresses, to, as it were, sum up all the evidence that they have led in court, to, as it were, make a last-ditch attempt at convincing the judge to take their side. So all these have now been filed by the court. The judge is now going to study that. It is going to form part of he writing his judgment for the case now to be heard, for the judgment now to be delivered on the 4th of December.
So I saw the Attorney General also here. Was he in court in respect of this case?
No, he did not show up at that venue, but the Attorney General actually went to the courtroom where the minority leader, Dr. Kisela Tufosin's case is being heard. They are still doing case management. They are trying for the defense now to call subsequent witnesses, and so we are going to hear from the former governor of the Bank of Ghana, Dr. Wampa. We are going to hear from a former health minister, Mr. Alex Segbefia, as to how long the cross-examination will be, the examination in chief. The Attorney General himself was around. He said generally that he wanted to do so in an hour. the lawyers for Mr. Atufosin at some point said that they wanted to have 3 hours. The judge would not have any of that. So there was that. And then the final case we have been following before we hand over back to studio for the rest of the conversation to continue is Dr. Stephen Opuni, the former CEO of Cocoa Board. Today he made another attempt to pause his case.
So just to take you back, so what's about this case?
The Dr. Stephen Opuni and the founder of Agricult, Stephen Agongu, are standing trial for some contract that is signed that the state believes that there was malfeasance involved, there was corruption, that the state has not been properly represented by the way Dr. Stephen Opuni and Seydou Agongu, a private businessman, handled that case. So they are standing trial, and this case has been going on.
We'll definitely be bringing you some updates as and when we have them. My colleagues Kuku Asante and also Richard Kujunyako, they're giving us the latest judgment date is in court, especially when it comes to the case of William Essien, 15 years plus hard labor for him in the defunct Capital Bank case. And also we're learning more about the Agricult and Cocoa Board CEO case, which is also related to the banking sector. To some other corruption-related issues. Then we're learning of the Office of the Special Prosecutor, where Cecilia Abinadapa is also in court today with the OSP making another case for why he believes that the former sanitation minister is guilty. So let's hear from private legal practitioner Kweku Pencil, who's joining us via Zoom now. Quite a very busy day in court, lawyer. But let's start off with Cecilia Abinadapa, because we know that there's a petition actually to the Chief Justice, the feeling that the judge handling all her cases appear to be prejudiced. What's your legal take on this matter?
You're talking about the petition by the OSP to the Chief Justice?
Precisely, sir.
Yeah, I will put it this way. There is an aspect of the rules of court that relates to what we call it nemo judice in causa sua. It's a Latin expression for no man shall be a judge in his own cause. It relates to any situation in which there is some evidence or possibly perception that whoever is presiding over a case, in the case of judges, whoever is presiding over a case has some interest or has some bias or has some attitude that makes it appear that the judge will be incapable of delivering justice in accordance with law. Whenever you've got that kind of impression, then it entitles you to bring a proper application before the court to do what we call on the basis of an allegation that for some just or sufficient reason, the judge is incapable of administering justice in accordance with law. In other words, the judge is not fairly balanced in the scales of justice to do that. Now, that's what I hear the OSP is trying to do. As to whether the procedure he has adopted is the right procedure is a different matter altogether. And I want to speak to that. Because if a matter before court and a judge consistently does things in a particular way, in this case, if my understanding is right, it's possibly about the judge's response to the case of the OSP, which is to mean or to suggest that he's being denied, oppose all the reliefs and the requests and whatever it's asking for. If that is so, then these decisions that the judge is making, he may be wrong, he may be right, he may be totally wrong. People must not believe that every time a judge makes a ruling or takes a decision, the judge says as King Solomon. He does not. But the response to that kind of consistency in refusing a request is by way of lodging an appeal. Because when you've done an appeal, you essentially disagree with what the judge has said or what the judge decision is. And then you give an opportunity for a 3-member panel, what we call the 3 wise men, to give a decision which then may or may not agree with what the judge is saying. So that's the normal way of attacking a judge's decision, however you feel about it. So the mere fact that a judge rules consistent in a particular direction, it does not itself suggest that the judge is biased. But if you believe or have evidence, please, I'm talking about evidence, because the letter that
unfortunately,
has written,
unfortunately, we've run out of time, sir. We'll have to cut it short here. Kweku Pencil, a lawyer there, joining us to analyze these matters. Thank you. Apologies there. We're running out of time. You're watching The Pulse. When we get back, we'll bring you some other stories.